even though as it begins to feel like summer. This is an important topic that we're going to be discussing today, and I think one of the critical precursors to being able to assess machine learning systems for bias and fairness. Often, conversation about AI fairness gets into questions related to metrics and which metrics might be applicable to a particular use case, and how can you determine which ones are relevant for your application. But before you even get there, you're likely, as a practitioner, going to be confronted with the gaps that you may have in your data sets around gender and race data or demographic data. So today we're very happy at Armilla to have a number of experts join us today to help unpack this topic. And before we get into this, I just want to share a little bit about Armilla, if you're not familiar with what we do as a company, and a little bit of information relevant to this topic if it is somewhat new to you. So at Armilla, we provide third-party AI testing, assessment, and insurance programs. We do this to help enterprises prove AI quality, compliance, and eliminate risk. And this is how we get into how we've been exposed to a number of these situations working across different industries, where we have to work with data science teams as they navigate different options they have to address these gaps in demographic data sets. A bit more about what we're doing at Armilla. We provide an assessment, as I mentioned, and a warranty, which is our first insurance product backed by Swiss Re, Chaucer, and Greenlight. This is a way for us to work with AI teams to help guarantee certain performance indicators, including fairness of AI systems. We've been working in HR tech, insurtech, health tech, and fintech on fairness assessments, as I mentioned. And we've seen this topic come up time and time again. You can go to websites like the OECD's catalog of tools and metrics for trustworthy AI, which I believe was a result of a collaboration with NIST. And there you can see a list of dozens and dozens of fairness metrics, but yet there's not a whole lot of guidance when it comes to imputing or inferring demographic variables in data sets that you're hoping to use to measure and test for bias and fairness in these systems. Today, we're going to focus on some examples from HR tech, but also insurtech. We're really happy to have Chris Cooksey here from Guidewire, who has some experience, decades of experience in the insurance industry, and is very familiar with this topic and its origins. So we will have an industry-specific focus and aspects of the conversation today, but we're also hoping that it'll be broad enough to appeal to practitioners in a number of other industries, as well as researchers and policymakers who are helping to move this topic along. The common question we're going to be addressing is, how can you accurately measure fairness without access to sufficient representative demographic data for gender or race? So this is the core question that we're going to be asking each of the panelists today to talk about, and so the questions that we're going to be inviting the audience to submit. We really want to get to the bottom of this question and come away with whether you're a data science practitioner, a legal counsel working on these topics, or a policymaker that is interested in understanding how to translate important public policy objectives around AI fairness into actionable, accessible technical requirements for teams that are ultimately going to be responsible for meeting these new compliance measures. Just some brief materials on what we're talking about here, because I know some of our experts are going to get into this in greater detail. But today, when you think about the challenge of addressing demographic data gaps, there's really a few different options. These are just two, and I think Miranda will help unpack quite a few more. But the first thing you might think of is, well, why don't we have gender or race data in these data sets? Why don't we just collect and use this data for the purposes of testing for bias? Well, there are important challenges to this for businesses. For commercial reasons, whether you're in human resources, whether you're in financial services, you may not want to ask your customers for sensitive personal information on their gender or race. Then there's also existing privacy laws and anti-discrimination laws that might prevent you from asking for information that you don't need for a specific business purpose. So this hasn't really been a palatable option for a number of reasons across many industries. There's also some known imputation techniques. Some are being used, and we'll talk about this in a bit more detail in insurance regulations today, based on estimating the missing values using some combination of first and last name and maybe zip code to estimate with a high probability or varying probability whether an individual is of a certain gender or race. And then there are other new techniques that use machine learning. A well-known API is the NAMSOR API that is used to infer gender and race data from existing data sets. So these are just a few of the options on the table, and what that practitioners have in mind when they're beginning to look at data sets and to test machine learning systems for bias. One of the reasons we're having this discussion is because faced with these options, some policymakers are forcing the issue. And what do I mean by that? In a number of jurisdictions, there are new requirements for fairness in relation to AI or machine learning systems, whether in the EU or a local law in New York that is requiring bias audits of HR systems, certain automated employment decision-making tools. And then there's a draft AI testing regulation in Colorado, from the Division of Insurance, that is requiring a very specific imputation technique to be used by all insurers as they meet their new fairness auditing or fairness assessment requirements. So there's a number of different options on the table. Up until now, some of them haven't, as I mentioned, been very palatable or actionable at all for different teams for legal reasons or reasons of risk. But now companies are being either given those new options for example, with respect to collecting this data directly and using it for bias mitigation, or they're being asked to consider only one of a range of different imputation or inferencing techniques. And today, the goal is to get into some of the challenges or the pros and cons of each of these, and to hopefully come away with guidance for data science teams and other AI governance professionals who are trying to make the best of, I think we would all agree, some very imperfect conditions here. Okay, so with that, we're going to move to the first segment of our program, where I invite each of our panelists to open with some short remarks about their work in this area and some of the key issues that they see from their perspectives. We're going to begin with Miranda Bogan from the Center for Democracy and Technology. Miranda, I know you've been very interested in this topic longer than most in the AI field. So I'll just hand it over to you to take it away, introduce yourself, the work you're doing, and to share what you have to say. So thanks very much for being with us.
Absolutely. Thanks so much for having me. So as Phil said, my name is Miranda Bogan. I'm at the Center for Democracy and Technology, which is an advocacy and research organization based in DC that advocates for civil rights and civil liberties in the digital age. And specifically, I run a project there called the AI Governance Lab, where we're trying to bridge the gap between sort of policy conversations and implementation questions, because we know that's where the rubber meets the road, where a lot of questions that can remain unanswered in policy conversations really have to get answered in order to make progress on issues. And bias and discrimination in AI systems is one of those areas where there's a general consensus and in many cases requirements that this type of testing be done, but very rarely recognition of the challenges, specifically around demographic data, that it takes to kind of move forward in doing those measurements. And I first got interested in this topic back in maybe like 6 or 7 years ago, when there were pushes for some of these online platforms to seek out and mitigate discrimination on their platforms. But we had, the organization I worked with at the time, Upturn, were hearing from many of them that they felt sort of stuck because they didn't have the type of demographic data that traditional regulated institutions had, for example, employers or mortgage providers, for instance. And so we set out to do research, trying to understand the landscape, and identified sort of the history of the industries that were required to collect this data, were prohibited from collecting this data, and had kind of come to norms around collecting the data, which is what happened in the healthcare context, which was fascinating because it was one of those cases where there hadn't been clear guidance. There were sort of several years of efforts across stakeholders to figure out that moving forward was necessary in order to identify equity gaps, and ultimately a practice developed around collecting and imputing data in order to detect those gaps. Now, more recently at CDT, we did a report trying to map the landscape since then. What have organizations tried to do in order to make progress on these measurements when they don't have immediate access to demographic data? And the point, the purpose of doing this research was to try to unblock this conversation, because we know it can kind of get caught in circles of, but wait, should we value privacy more? But don't we need to kind of conduct these measurements? And we wanted to really lay out the menu of options and also disentangle the options for collection and measurement and sort of the complementary menu of options for safeguarding that data and those metrics, to make sure that if an organization does adopt one or several of those approaches, that they can make sure that those approaches are only used for measurement and potentially mitigating fairness issues, and are not at risk of being used for purposes that they weren't intended to, which could both erode trust and potentially violate other expectations as well as laws. So the report, we lay out sort of two main categories of methods to conduct these measurements. Basically, efforts where institutions need to measure disparities related to people. So when you're measuring a decision-making system that's impacting real individuals who have identity characteristics, and you're trying to kind of measure the distribution of outcomes related to those identity characteristics. And the second category is measuring disparities related to representations of people, which is more common in the generative AI space, or in sort of content analysis space, where maybe there's an image classification algorithm that could be differentiating among images of people, but where there's not a cognizable identity of a person that you necessarily have. And so it's more about observed characteristics or keywords or things like that. So just to kind of run through some of the methods, and Phil previewed two of obviously the main ones, which are collection, directly asking individuals, and that's seen as the gold standard, but obviously encounters several challenges, namely that people, even when offered the opportunity to provide that data, might choose not to. Response rates tend to be in the low 2 digits, or if not 1 digit or less, of percentage of response rates for self-identified characteristics. And within that, you also need to determine which categories you're collecting and how to aggregate them if you don't receive enough response within some of the smaller populations. So it's not, entirely straightforward in and of itself, but definitely allows for people to self-represent their identities, which can be, very complex and not aligned with categories that governments tend to use, because we have to grapple with that. Observation and inference is definitely widespread, especially in traditionally regulated industries, especially in the financial context and insurance. We see this quite a bit as well, some of these existing methods. And some of the methods have been critiqued because they're not precise. They do have limitations for smaller populations, but there's also been research indicating that they remain useful to identify directional disparities and inform the prioritization of interventions. And so while there are some limitations, they do have a lot of utility. And the real question that comes up in observation and inference and imputation is how not to presume things about individuals in a way that sort of durably assigns an identity characteristic to them that they haven't identified. And so there's some really interesting methods to do population level analysis, to sort of immediately aggregate information so that we're not storing predictions against individuals in a way that might challenge some of those privacy laws like CCPA or GDPR. But in this context, there's definitely representational harms that can happen, and so you want to kind of carefully balance the method and how you're going about inferring. And then there might be characteristics that just aren't well suited for this approach because they're inherently unobservable characteristics, or there's extreme sensitivity in sort of presuming these things about people, and so definitely not one we want to say is a blanket green light to do this, but it also is a common practice in gender and race, for example. We also saw a lot of examples of the use of proxies and surrogate characteristics. And in particular, I wanted to differentiate those categories from observation and imputation because it can be useful to do measurements on characteristics that are related to a demographic characteristic, but that doesn't mean we're predicting that demographic characteristic about a person. So doing measurement based on location or language spoken, or use of different types of phones, right, that might relate to socioeconomic characteristics, but it doesn't have to require the jump from looking at that data point to an assumption about an individual's demographic characteristics. So there's some potential room there to say, what data do we have? What signals might be relevant to understanding disparities across populations, but not sort of presuming those ought to be treated as proxies such that they should be assumed to be inferences about something sensitive about people. We also saw some examples of the use of auxiliary characteristics, so either public data sets, sort of voting data sets. Sometimes organizations were able to partner, or let's say an HR tech company was able to create an agreement with their client who did have demographic data, because that is something that employers collect. And in many cases, there's some interesting privacy enhancing approaches that can be used to not share the data sets directly, but still conduct measurements on them. Now, in this case, again, we don't want to sort of give a green light to obtaining things like data sets from data brokers, for instance, but rather thinking about, to the extent that an organization has access to data, just not immediately directly, how might that data be compared against the outcome data that they have to conduct measurements? And we also saw some interesting work using like unlabeled sort of cohort discovery or clustering based approaches that actually don't require the strict definition of categories or the inference of specific information about individuals, but identified where might there be groups who are disproportionately receiving less optimal outcomes, or a system is not working adequately for them, and trying to figure out what are the characteristics that are most salient to that failure or those outcomes, regardless of whether they relate to a demographic characteristic, because it's very likely that that failure correlates in some way. And so addressing that gap might still lead to improvements in disparities. And so that's something that I think organizations should consider as they're trying to navigate the space and make progress, even if they don't have structured data by which to do measurements. Synthetic data also came up, but that's also, another place where the production of synthetic data can have its own biases. So again, a trade-off of how might you create data that generates insights while also not having those insights reinforce sort of gaps in your ability to measure. Exploratory analysis, so trying to look for failure modes specifically without looking for the cohorts who they're affecting initially. And finally, qualitative research remains incredibly important. Quantitative measurements, even in their best form, can miss important sort of subcommunities, can miss important nuances. can overlook assumptions and kind of how the models and systems are built in general. So in addition to those methods, we talk about a variety of different approaches for handling those characteristics against things like pseudonymization, infrastructure controls to keep these methods and data separate so that they can't leak into other systems for use in decision making, which would be undesirable. Encryption of characteristics or encryption during computational processes to make sure that data is not leaking. Short retention periods or ephemerality of predictions during the imputation process were some interesting examples. Aggregation, differential privacy, as well as organizational controls and sort of potentially designating certain teams to handle this data or do measurements so that teams that were involved in product development wouldn't be tempted to use the data for something they oughtn't. So the report goes quite a bit deeper into each of these methods. It's sort of their opportunities, their limitations, and the implications that each of them have for the fidelity of the measurements that come out of them and how that should be thought about in terms of detecting disparities. But definitely, I'm excited for the conversation and welcome questions.
Thanks, Miranda. And for everyone in attendance, I've just copied the link to Miranda's report with CDT in the chat. So please do take a look. There's really a wealth of information in there about different approaches and some of the studies on how these have been working. And we'll be getting back into it as we get to the panel discussion. Mariah, I'd like to turn to you, Mariah Jaworski from Clark Hill, to provide a legal perspective on what you're seeing in relation to this topic with work with your clients that I know you're doing from HR to insurance. Help us, get a better understanding of the legal landscape and how the shifting legal landscape is coloring some of the decisions that teams you're working with are facing.
Sure. And thanks, Phil. And thanks, Miranda, for that very interesting overview. I intend to circulate your report widely amongst my client base. As Phil mentioned, my name is Mariah Jaworski. I'm a data privacy attorney with Clark Hill. Clark Hill is an international law firm with offices throughout the United States, Ireland, and Mexico. The role that I play is as outside counsel to regulated entities. And in this instance, we're really talking about insurers, HR tech vendors, and employers who may be in scope for some of these emerging or enacted laws. Specifically in New York City, we have New York Local Law 144, and we have in Colorado, the Department of Insurance's model testing regulation that's currently geared towards life insurance lines, but will be more widely applicable. But even beyond those arguably regulated entities, there is a lot of interest amongst all enterprises that are deploying and leveraging AI tools or any tools for purposes of making automated decisions to understand really what their testing obligations are. And I have that boots on the ground perspective. So I wanted to level set and really hit on something that Miranda and Phil both touched on, which is why do we have these demographic gaps to begin with, right? And that's really because there are either express legal prohibitions in anti-discrimination laws or in anti-discrimination dictates that are in other laws like insurance laws and financial services laws, et cetera, or because we've just determined those norms that enterprises have adopted that have sort of worked to understand that the way to mitigate risk associated with discriminatory outcomes is to not collect the information in the first instance. And at least amongst my client base, there is a real hesitancy to start collecting that information now. Miranda's point about how collection is the gold star is very well taken, but we're talking about sort of decades-long norms that have been established. And an example of that, which I think we really need to emphasize is, most recently we had the reemergence of DEI initiatives, of pay equity analyses. And in those instances, employers in particular have been mandated in certain contexts to collect this information. And to Miranda's point, the collection rates have been very low. And even when they collect that information, they're doing so mindful of other data privacy principles such as data minimization, right? They're doing what we want them to be doing, which is they're collecting it for a very specific use purpose. They're maintaining it for that purpose, and then they're deleting it. They're not retaining this information for long periods of time, and they're not leveraging it for secondary purposes such as testing tools. So there is that norm that I think we now either need to counteract or we need to just accept. So when I work with clients, one part of the analysis is, do we collect or do we start focusing on these other the other testing techniques, such as imputation, such as the RAND standard in the DOI law, such as the 4/5 rule, et cetera. So the role that we play as attorneys is we work with consultants, Armilla being one of them, but others as well, to create an attorney-client privilege framework where a business or enterprise can feel very comfortable retaining a sophisticated vendor who has the ability and understanding to test the data and to try out various imputation methods. So an example of this that we have seen in practice has been in the HR tech context, testing an HR tech model for compliance with New York's local law 144, lacking in certain demographic race particular data, and working with a vendor to create proprietary synthetic data to allow that testing to occur. I think the feedback from the market with respect to the Department of Insurance, the Colorado Department of Insurance's focus on or specification with the RAND standard and specifically the surname and geocoding is that it's very prescriptive. I think industry would like to see more principles-oriented approaches when it comes to allowing companies to kind of figure out what testing method would work best for them based on the data that they already have, based on the vendor that they're working with. And to that end, we do have the New York Department of Financial Services circular letters, and New York has really adopted a more principles-based, kind of fairness-based principles that allow for assessments, that allow enterprises to kind of determine what assessments would work best for them. So that's kind of the role of the attorney in all of this. In addition to creating the attorney-client privilege framework, which I want to emphasize, it's important not just because we have these emerging regulatory regimes, but also because in the United States, we have a very creative and litigious plaintiffs bar. And that plaintiffs bar has already brought lawsuits, largely against insurers, for their use of AI and decision-making tools in claims handling processes. So in the two sort of main contexts have been in denying medical claims and in denying or in prolonging the claims processing for property and casualty claims. Why do I mention litigation? Litigation is important because not only do we want to protect these testing methods and these analyses under the guise of attorney-client privilege if we can, but also because even if we as an enterprise are not directly subject to the 2 or 3 regulations that I've mentioned, there is an awareness, there is case law, there is precedent in the United States going back to at least 2016 that says, if you're deploying these tools, you need to be testing and monitoring them. So as a legal defense to potential claims, that's another aspect of this sort of analysis that many businesses are conducting. And in that context, if I need to defend to a court, if I need to defend against a plaintiff's class action lawsuit, what is my testing strategy there? So that's sort of the role of the attorney in all of this. And I look forward to the panel discussion.
Thanks, Mariah. So Chris, we'll come to you now. And as I mentioned at the beginning, you've had a long career in the insurance industry. And as we were discussing this issue in advance of our discussion today, you mentioned that people might not understand why this is kind of emerging as an altogether new issue for the insurance industry. So I'd just love to invite you to walk us through how this issue and these challenges have been experienced by yourself, by data scientists that you work with, and what makes this a bit of a unique context today. Thanks, Chris.
Okay, thanks. Yeah, Chris Cooksey. I work for Guidewire Software, which is a leading provider of core operating systems for insurance companies, so policy admin systems, claims systems, but with that has analytics components as well, which is why someone like myself works here. I'm an actuary by background. I'm a credentialed actuary with the Casualty Actuarial Society, and started my career working at an insurance company for 12 years doing pricing of personal lines, auto and homeowners insurance. Moved into the predictive modeling space and been a predictive modeling practitioner ever since. So I thought I'd bring that perspective of sort of what is it like from the practitioner's perspective, because it is kind of weird because we've always been ethical. We've tried to be ethical. We've tried to do our best and do our due diligence when building models. We operate within a company that expects ethical behavior. We operate within an industry that is regulated, highly regulated by departments of insurance. And as an actuary, I'm part of a society which has ethical expectations, standards of behavior, professionalism, and whatnot. And yet it feels like something changed, right? Something changed around about 2021. And to me, that's worth kind of thinking about. What changed? If we've always sort of been trying to be ethical, what changed is now we have new regulations and new expectations. And I think it kind of goes back to the kinds of predictive modeling that we were doing 20 years ago, which used simpler techniques and used more limited data sets that were more confined to just what the company was collecting in order to do its business. But over time, right, the variety of techniques has expanded, the complexity of those techniques expanded, external and public data sources have expanded. And now the idea that we can say, look, I know what the protected attributes are. We didn't use them in this modeling technique. Shoot, we don't even have them on the data set. So since I didn't do anything wrong, therefore there's not a problem. That might have been a sufficient answer in the past. In fact, it's not an unreasonable answer in the past, given sort of what we were doing, to say, hey, I don't think there's a problem here because here's what we did, and it was all pretty straightforward. But as things get less straightforward, that sort of passive answer of I didn't do anything wrong and so therefore there's not a problem becomes less adequate. And what shifted in that sort of 2021 timeframe is just that idea crystallized. I would not say that during that time a problem was found and then new regulations were posed. I just think the idea that what we're doing is not adequate to the techniques we're bringing to the table crystallized as an idea, so that passive answer wasn't good enough, and then both sort of explicitly in some of these regulations, but also just generally as an expectation, there's now an expectation that you need a more active answer to saying, no, I looked and there's not a problem, right? And that is now more of the expectation for the kind of work that we're doing. Now, as a practitioner, that leads to an immediate problem. It's like, look with what? I don't have this data. That was the whole point. The whole point of this is I've spent my entire career, the company's whole existence, not collecting this data. Which, as Mariah said, that sets up industry like customer norms. Customers know that you don't ask about race when you're buying insurance, and if you all of a sudden start doing it, well, that's kind of weird, right? There are obstacles to doing that. And so then you have to say, okay, well, as a practitioner in insurance, it's good to keep in mind that I kind of work in a little bit of an insular industry that has such peculiarities to it that there is their own practitioners that tend to be focused on that industry alone. There are regulators that focus on that industry alone. Suddenly, when you say, well, I don't have that data, what can be done? Well, if you start looking around, then you find out, oh, other people have been grappling with this. These techniques like the Bayesian inference do exist. We don't have to create them from scratch. But now we're in a position of saying, okay, well, I'm not exactly educated for this, and now I've got to add this to what I'm doing, which is just a human response, and that's fair enough. But there are ways to get educated. There are groups that have been working on this, like the paper that Miranda put together sounds like an excellent resource. I looked through it briefly, and there's a ton of information there. And the professional societies and insurers have not been absent to this. In 2022, the Casualty Actuarial Society put out a series of 4 papers on race and insurance pricing, which are excellent. They set a lot of the baselines, especially for practitioners who may never heard of disparate treatment versus, disparate impact. Well, what's that about? So there are resources there for practitioners to get on board and get educated with those. And when it comes to sort of the sense that it's like, good Lord, I'm a practitioner. Why? I'm not educated in this. It's not my job. How do I deal with this? My response to that kind of worry, and it is a worry, and like I said, it's a natural worry, but my kind of response is that what we are educated for as practitioners, what we are a specialist in, is knowing what the data does and doesn't say, knowing what techniques can say about the data versus what their limitations are. And when you think about a conversation about equity and the impact of business practices and insurance, what that conversation desperately needs is data. What that conversation desperately needs is information to actually specify, because wouldn't it be great if we did some testing that we thought was valid and we looked at it and we said, oh, actually, we're good. There's no particular bias here. Let's move on. That would be a fantastic answer. But the problem is right now, we can't even make that statement because we just don't know. And so the more we do this testing, the more that results are socialized throughout the industry with regulators, the more we get a sense of whether there's a problem and where the problem might be and what the potential solutions might be, then the conversation is much more fruitful. And that's what practitioners, I think, like myself, can bring to the table that is really of value and is something that, hopefully we're not afraid of and can do. So I'll save it there and
Thanks, Chris.
look forward to the discussion.
Terrific. Riva, I think it's a great time in the conversation to come to you. And as we started with Miranda, kind of laying out some of the history and some of the empirical studies into the various options on the table. As choices become more complex, and Mariah and Chris provided helpful legal and data science industry perspectives. I think there could be a really interesting role for organizations that are developing frameworks and standards to help provide guidance here. So I'd love to hear from you. You're also an expert in bias, working at NIST. I'll just let you take it away, really, and help us understand where practitioners can go to for guidance and what this might look like.
Yeah, thanks. Thanks for having me. Excited to close out this part of the discussion. My name is Riva Schwartz. I'm a research scientist here at NIST, the National Institute of Standards and Technology. We are part of the Department of Commerce. Our mission is to promote U.S. innovation and industrial competitiveness by advancing measurement science, standards, and technology. Our work here, I have been part of the Trustworthy and Responsible AI team here. Trustworthy AI is about, is fairness and bias kind of get wrapped up in trustworthiness, but it's really just making sure that the technology is performing in ways that do not cause negative impacts and are able to maximize the benefits of AI. And that we developed a framework that was delivered, it was congressionally mandated in 2021. We delivered that in January 2023, along with a playbook to help. It's a voluntary resource. It is not required. It is not regulation. It is not compliance. To help any stakeholder in any sector to think about how to manage the risks posed by AI to individuals, communities, society at large, even the environment. And to do this through making their systems more trustworthy. And fairness and management of harmful bias is one of seven trustworthy characteristics. Back in March 2022, our team authored a document called a classic. We name our documents by numbers here because we are metrologists, and that's just how we live here at NIST. It's called Special Publication 1270, towards a standard for managing the risks posed by the risk of bias for artificial intelligence. And the big takeaway of our document on bias is, it's a couple of things. First of all, I always like to tell people the question isn't if there is bias in a system. There is bias everywhere. It is part of life. We cannot walk around and make sense of information without bias. It is what type of bias, and is it causing harm? And if so, for whom is it causing harm? So, so the big takeaway, is from that whole document is that we tried to expand the way people think of bias to move beyond computational forms of bias, which is kind of this idea that all the harm stem from challenges just within the data, just within the model or the algorithm. Of course, so we refer to this as computational bias. This is really just when any error that results from the sample not being representative, or which is a problem when we don't have the right type of data. But even there are models that we can create demographic balance for, and we do have data representativeness, but we still have harmful biases. So we describe and introduce two different types of categories of bias we refer to as systemic bias and human cognitive bias. Systemic bias is also sometimes referred to as institutional or historic bias. It's really, it results in, certain social groups, in this case, since we're talking about demography, certain social groups being advantaged or favored and others being disadvantaged, which is obviously a law, a problem with, you're getting in trouble with the law there. So this type of bias is present in data sets, but it's also prevalent in the organizational norms, practices, and processes across the AI lifecycle and how AI systems are used. So word embeddings is a good example here that when people are, in predictive systems for quite a while, that when you would request to show an image of a doctor or a lawyer, or that in HR, people would presume that the doctors or the lawyers were men and not women. And then there's human cognitive bias, the other type, which is really how individuals or groups make sense of information when making decisions. So if you think about all the decisions across the AI lifecycle and how and where AI is designed, developed, and used, there are opportunities for these kinds of biases to occur, especially when we do not have standards of ethics or scientific integrity practices to make sure that decisions are framed within a certain set of criteria. So our approaches, though, are really just kind of even still, so that paper has been out now 2 years. Many of our approaches are still designed to address that one form of bias, the computational forms of bias, but are not really able to capture the other ones. And that's because it's really difficult, right? It's really, really hard. And it also is at the organizational level, it's highly contextual and highly variable. So important to note, just a reminder, biases are not always harmful. And because bias is prevalent in human decision-making, that even when it is harmful, the bias can occur even in the absence of prejudice, partiality, or discriminatory intent. It is just the way humans are. But so with the rise of generative AI, all of these factors explode in number and complexity. Generative AI is so easy to use that it can be thought of and is often referred to as multi-purpose or general purpose. And it brings all sorts of risks. When anybody can interact with the technology, these risks explode, and it's in many ways related to this massive level of variability and how people interact with it and what they expect from it, and brings new sets of questions at this intersection that Miranda had introduced so well, which is this intersection of demographic inference and what people expect when they're interacting with AI. So if we're with generative AI, so if the system, if the generative AI model is trying to, give the person the answer that they want, and they, presume certain things about the person, we have all like exploding amounts of risks. So, so bias in generative AI models is, and the data underlying those models can, just like in predictive systems, create representational harms. They can perpetuate and amplify discrimination based on race and other demographics. There's plenty of examples out there of, text to image models, which have been shown to produce stereotyped content, again, back to judges, doctors, lawyers, give me an image of that, and we show men. But we also have difficulty producing non-stereotyped content, even when prompted to do so. So hey, ChatGPT, can you show me an image, or any model, can you show me an image of someone who is disabled leading a meeting instead of in the meeting? And that's been difficult. So the newer updates of models are performing much better in this sense, but out of the box, it was an issue because it's bigger than data. So, so to address these issues with generative AI, last summer here at NIST, we formed and led a public work, what we refer to as a public working group on generative AI. We had over 1,000 active participants working with us to think about what are the risks that are unique to or exacerbated by generative AI. So unique to those that are not, for other forms of AI. And that work and the public working group ended in November. And then we leveraged all of that input for a public draft of one of our presidential executive order on AI deliverables. That document was actually released, posted for public comment at the end of April. Comments closed at the top of the month, just in June, and we will get that final document out in July. And I just want to take just like maybe 60, 90 seconds to note that we can also consider another way we can think about fairness and other negative impacts is to get people's responses. Maybe not so much. So at NIST, we can't force companies to do any of those things. What we can do and what we do here is create evaluations, scientific evaluations, and we have kicked off one about a month ago called ARIA, Assessing Risks and Impacts of AI, and we will evaluate how systems create risk and impact in real world settings. And one of we'll do that at 3 levels, model testing, red teaming, and field testing. In the field testing level, we're going to be able to give thousands of people, regular people, interacting with models just like they normally would, generative AI, large language models. And we're going to ask them to provide feedback about those experiences. And we will have that demographic information because these are scientific experiments. They're treated as human subjects. And we'll be able to validate some of these approaches and see what kind of mitigations can assist in reducing some of these kinds of biases, but then also under what conditions these kinds of risks and impacts might occur. And I'll just leave it at that. Thank you.
Thanks very much, Riva. So we have about just over 10 minutes for some questions, and so it's good timing that we just had one submitted, and I think it's an excellent question. Maybe we'll go to Miranda and Chris, since well, Miranda, you've had the longest to wait, and you've had the benefit of hearing from the other panelists. But this question says, if you find bias in your model or data when testing using imputed protected attributes, what would be your go-to suggestions for addressing this, given that the protected attributes are not in the data set? So it could be the question could be for anyone. This person has an interest in the insurance space, but maybe worded differently. A question that I had is, if you're starting out and you're working with imputation techniques, what advice would you give to data scientists confronting this issue? Where would you start?
Yeah, it's a really great question, but I actually think it's equally relevant to any measurement you do with any method, including self-identified data, because presumably that data isn't in your model to begin with because of sort of discrimination concerns. Two directions that are kind of straightforward to go to, and the White House Blueprint for an AI Bill of Rights kind of talks about this, but generally in my conversations among civil society and policymakers, the expectations are reasonably straightforward. The first is identify whether there are inputs into the model that are like very blatant proxies for that information, and you can conduct those measurements using the same methods, and then you have to sort of reflect on whether those inputs are reasonably related to the thing that's being predicted, and whether the assumptions about how predictive they are grounded in empirical evidence. And I think there are examples where those assumptions seem to be grounded in empirical evidence. For example, medical predictions that used race as inputs, and that was sort of a standard practice for a while. And only recently, upon reflection and continued research, people realized that those were faulty assumptions, and those shouldn't have been signals in the model in the first place. So simply looking at like reviewing the model itself, and to the extent there are disparities, are there components of the model that on reflection maybe shouldn't be in there? But the second piece, and again, this is really, any measurement can lead you in this direction if you identify disparities, is to look for less discriminatory alternatives, from the sort of legal concept of less discriminatory alternatives. Now, in the law, there's like a burden shifting sort of question, and who's actually responsible for finding those less discriminatory alternatives. But when you reflect on it, the developers of these AI systems are in the best position to search for alternative models, or even just test a variety of different models, and see which ones are reasonably supportive of the business goal, while also resulting in the smallest disparities based on these measurements. And like it can, like, fairness and non-discrimination in AI can feel quite complicated. There's so many different metrics you can use. They all have different implications and whatnot. But at the end of the day, what folks really would like to see is this search for what is the model that is the sort of results in the most equitable outcomes, which doesn't require introducing the demographic data or method into the model development itself. It simply requires comparing a variety of models, which many organizations are doing anyway, in order to find the one that best serves their goals, is most accurate, fewest errors in general, et cetera. And so just adding an additional consideration at that point that takes into account these measurements would be a really welcome development, to the extent it isn't happening already, which is our observation. Generally in non-explicitly regulated industries, we don't see that as a standard practice, and we hope to.
Thanks.
Yeah.
Go ahead, Chris.
When I was thinking about it from the perspective of, if I found something like that, I would really want to start thinking about why, and is it something that because of historical or structural biases in the data, that the data doesn't really mean what we thought it meant, which can certainly be the case, like with the health and race example. Sometimes the data means what it says, and then you have to figure out why. And maybe there is a group that has a higher risk profile, but when you look at it, they live in more cat-prone areas just because they do. Well, that's still a legitimate risk that from an insurance perspective, it's okay to grapple with. That's kind of one answer. There's another, though, the sort of more worst case scenario is that the discrepancy exists. You can't figure out why. And then what? Do you just say, I'm not going to use this part? Let's say we're talking about using prior convictions as an indicator for future auto risk, which is perfectly valid in the data. But if you start combining that with questions of policing practices and is it fair, it's like you may get to a point where you have to say, do we need to do this at all? It does appear to be a valid discriminator of risk, but maybe it's something socially we just want to choose not to do. And then that's where it's going to be difficult for individual companies to act on it by themselves. But if we find that in the data, if we socialize the result, if it gets talked about, there may be room for then a social answer through the use of regulations or just agreed practice to change those kinds of practices. But you don't start that conversation until you elevate it. So even in the worst case scenario, finding something like that allows you to bring it to the table.
I'll just jump in with a governance consideration. I think Miranda and Chris both touched on the technical analysis that needs to occur when you've identified some form of bias in the data sets itself. But don't forget how you need to fit mitigation into your larger risk management and governance framework. And we see that under National Association of Insurance Commissioners model rules. We see that in the DOI Colorado regs. We see that in all kind of emerging regimes. We need a governance framework that accommodates mitigation. And even if our decision, and that justifies the decision that we made with respect to mitigation, and whatever outcome occurred. And specifically as it pertains to the Colorado regs, we need to be documenting this. I mean, the Colorado regs have adherence to this idea of a diary, a dashboard. We need to be just documenting our policies and procedures and our testings.
Documentation for sure, as one governance, and I suppose I should say measurement, because that is what we live and breathe here at NIST. But I think I'm going to go actually with something that we put in our map function in the AI risk management framework, which is that the importance of interdisciplinary teams cannot be understated. That when everybody's looking at the problem from one way of seeing things, we miss risks. We just can't cover these things the way we need to, especially in this incredibly complex set that of challenges we find ourselves in with generative AI. But we say this, knowing interdisciplinary work isn't easy. It's hard for people to communicate across these silos. But I think the benefits of that can't be overstated.
No, we only have just a few minutes here, but the last question I wanted to put to each of you is, we've mentioned this at the beginning, but we have policymakers or regulators that are issuing guidance that is to set expectations for industries. I'm thinking again about insurance, but even Miranda, what you mentioned about proxy risk assessments and looking what the variables are actually whether and how they're contributing to the output. This hasn't been included by regulators in guidance in New York State, for instance. So what would you like policymakers or regulators to consider, or in terms of approaches, or a balance between different approaches as they're looking at these public policy objectives that are around AI fairness, and asking enterprise data science teams, organizations, other practitioners to consider a variety of options or make specific choices even. What would be your message to policymakers on this topic? What would you like them to know?
I can kick it off again to just go in a circle. I think, we've, as a field, come to understand that the approach of decades past of saying just by not collecting the data will protect us against the outcomes that we're afraid of is not sufficient. The characteristics of AI are such that they will end up reflecting these disparities, as Chris mentioned. And so, some kind of requirement for proactively considering the way in which disparities can manifest in systems is necessary to get organizations to sufficiently invest in this work and make sure their teams are equipped to do the work. And policymakers, I think, in that vein, also have to recognize that that does come with some need for a set of approaches or methodologies that are deemed reasonable, as well as articulating some safeguards that policymakers expect organizations to implement in order to feel confident that that data is not using in a way it shouldn't be used. So we saw some, we've seen a little bit of this come out in the EU AI Act, where there's some allowance for the collection and use of this data for fairness and non-discrimination purposes, although only for systems deemed high risk, which there are many other systems that might be high risk but not have fallen into that category. We saw some discussion of this in the American Privacy Rights Act under discussion, although that is backsliding a little bit on that front. But I think this will continue to look for articulations that this expectation is inherent in the development of technology, and also an understanding that that means updating practices within industry so that we can kind of break through some of those blocks that norms have kind of set over the last years.
Thanks, Miranda. I know we're at time. I just want to give an opportunity to Chris, Mariah, or Riva for a final comment before we sign off? I know there's someone on joining us today who have a hard stop.
I think as just a final comment, I would like to stress that for many enterprises, there's a major intimidation factor here, and there's a major learning curve. We take for granted, we talk about privacy enhancing technologies, we talk about model testing and imputation techniques. For many organizations outside of like the Fortune 100, this is Greek to them. So I really believe that continued education, I'm going to be distributing both the NIST study and the CDT report, and just continued resources and public-private partnership opportunities for sharing and educating is really critical to advancement of these public policy goals.
Yeah, I'll jump in because my thoughts were similar, that if I could recommend anything, it would just be that collaborative approach between public and private. Don't be so intimidated that you come in defensive, and regulators understand the sort of real operating environments that companies are struggling with. If they talk collaboratively and understand each other, we can make progress and get to a better place.
Thanks, Chris. And I think we'll revamp. I know you also have to go, but if I'll just add that I've seen, and in the last 6 months, well, we've all seen insurance regulators in particular referencing existing frameworks as a starting point, like the NIST AI risk management framework. I think this is a really positive step, so that industries can coalesce around common approaches, and we can hopefully all build from there. So. Maybe with that, I'll just thank each of the panelists for joining today. Really appreciate what you had to say, and thanks very much. And for all those attending, thanks for your time. If you have other questions, don't hesitate to send them on to us. We'll be happy to chat more offline. Thanks very much, everybody.